Hello, Canada. My name is KevinJJohnston, Canada's #1 tax expert. I have told you time and time again that you do not, as an employer, need to cooperate with any garnishment orders that you get from the CRA about your staff. They will do nothing if you refuse to cooperate, and I mean nothing. The brief history of the conversation that you're going to hear is that a very rude agent decided to tell me that I had to take $49,000 away from my staff member and give it to them and not my staff member. Well, I told that particular individual I was not going to cooperate. That individual got angry with me, and I said, have a supervisor call. Supposedly, the lady calling me in this conversation was a supervisor, to which we find out she's not. But nonetheless, I want you to pay attention to the entire conversation and then understand for yourself by the end of it that you do not have to garnish the wages of any of your staff. And if you do, you're a coward. Listen to this. Hello?
Hi, is available?
You've got him.
Hi, my name is Jessica James. I'm calling from Canada Revenue Agency. Do you have a few minutes for me?
I would love to chat with you. Go ahead.
Okay, sounds good. I'm calling on behalf of one of my colleagues. I understand that you had spoken with them on there was November 18th or so, I believe was the date that you had
In reference
spoken
to
with them.
which client or in reference to which product?
Oh, it was a garnishment that had been sent for an employee last name. Oh, sorry. I apologize. Yes.
Yeah, no problem at all.
Yeah.
Let me grab my notes. Go ahead.
Okay. I was going to say, so my understanding is that there was a bit of confusion with the garnishment that was sent, so I wanted to call and, I guess, kind of follow up with you on it.
Okay, well, it's real simple. Taxes had not been done, and we have to take a little bit of responsibility for that. There was some lateness on our end in getting that done. We have paid for our accountant to do them. Actually does not owe any taxes at all. In fact, as far as I remember, the CRA will be owing him some money. So we stated that we were going to decline the offer to take money away from, considering that he doesn't owe you any and you're going to be getting his tax file shortly. We've decided to have our tax lawyer send all the package in so there's no confusion. And now, as far as I understand, it's going to be sent by UPS overnight as early as Wednesday of this week.
Okay, so just so I have this correct, you're not the employer, you're accountant, is that right?
No. I'm I'm the 51% shareholder. So what I say goes.
Okay, so with that garnishment that was sent, regardless of if had actually filed his own taxes or if they were assessed on behalf of the agency, those funds that the garnishment was sent for are still legally collectible, and that garnishment does have to be followed. It is a legal document. Canada Revenue Agency does not require a court order for a garnishment to be sent out. Other businesses, yes. Canada Revenue Agency gets to bypass all that. The garnishment goes straight out. So with his taxes, I'm still done. I'm not done yet. With his filings that he's doing, he can go ahead and do those. Like if they are behind, which I can see at least several years are. So there were assessments done on his behalf because he chose to not file his own taxes.
No, again, he didn't choose to not do his taxes. I'm saying we made an error. It's entirely on me. And because it was on me, I paid for his taxes to get done.
So it's your fault that his taxes haven't been filed for 7 years?
Yeah, put it on me. I told you I'm fine with. I tried to explain to your, I guess, subordinate there that it was my fault. I apologized. She wanted to argue with me instead of have a conversation. So I'm glad that we're talking. You seem a lot more pleasant and reasonable. What I wanted to say was, we have cooperated with what we need to do, and that is to get his taxes up to date. Actually, they weren't even done. So What you're asking me to do is to collect money on an assessment, which you and I both know is a complete wild guess on behalf of the CRA. And I know that you believe it to be enforceable without a court order, but I tried explaining to your other staff member that there is no punishment that you could issue that would land us in prison or otherwise, and that if she was to take any action based on the fact that I have refused to cooperate, that's called malicious prosecution. Now, regrettably, I would have no choice but to file criminal charges against her or anyone else who chooses to react emotionally to my statement that I do not wish to hand over $50,000 to you for no reason whatsoever. My staff member does not owe you that. And yes, you do need a court order. I understand that you believe that the Income Tax Act is law and that it pertains to the general public, but I can assure you it does not. It's a set of rules and guidelines for the CRA to do what we call muscling of the general public. The general public doesn't know their rights. We do. That's why we're successful. We know all of our rights and we know the law. And I'm telling you that we very hurriedly did these taxes to appease the CRA, but you're telling me that you don't care that we're appeasing you and I'm supposed to steal $50,000 from a staff member and hand that to you. And I'm not going to do that.
So while you're assisting your employee with getting his returns filed, what years are you assisting him with getting filed?
Oh, the tax lawyer has all that. He's got the whole thing's done. Signed off on everything. And that's again between and the tax lawyer. That wasn't me sitting in the room doing taxes. I'm too busy selling and running a business.
Okay. So as a business owner, I'm sure you're aware of assessments that can be done on businesses when there are legal actions in place. Yes?
Oh, I'm aware that you might try. So, for example, you might get your backup about me saying I don't want to cooperate. And what you would do is you'll send a letter to our bank, which is a requirement to pay letter. And the banks, who are under no legal obligation whatsoever to hand the money over, may actually do so. At that point, we're going to file criminal charges against everybody who works for that branch for breach of trust, which it would be, and theft. We're also going to sue the bank for tort theft. The cool part about them giving you money is that we can't sue the CRA for that one because it's the bank that gives the money away. And we'll win. And as a businessman, when I sue the bank, I'll probably get back about 10 times what they've taken from us. Yes, I'm a very good businessman. I know what I'm talking about.
Okay, so you're actually mistaken.
Oh, go ahead. Tell me why I'm wrong.
Information. So it would be the business. There would be a memo assessment done. It's not like we can go straight to the corporation's business account. It's the corporation itself that would have a memo assessment against them for funds paid when there is legal action in place. So I guess with all your vast knowledge on things, I had assumed that you would have been aware of that fact, that there would be an assessment done. We can't go straight to the bank.
Oh, I know.
And
you can do
all this suing that you're talking about wanting to do, you can spend your dollars doing all those things, but it will be quite ineffective. So I was hoping to give you some knowledge in regards to the requirement to pay.
No, you were hoping to talk me into giving you money. No, that you're trying to talk me into giving you money. And what's happened here?
How much is the garnishment?
You're asking for somewhere around $49,000.
We're asking for it all in one lump sum.
Oh, I don't have the letter in front of me, but I know it's $49,000.
So how can we discuss this if you don't actually know what it says on the garnishment?
Well, I'm telling you that I'm not giving you money. We did the taxes.
So I just wanted to make you aware that if the corporation does not remit those required funds, then the corporation can be held liable for the arrears owing, which in turn could go to directors and shareholders. I guess I wanted you to be aware of that.
No, you're very kind to have said that. So what you're saying is, if we choose to ignore the garnishment order or refuse it, that you can take action, but you don't have to take action, correct?
there is the option to take
Right.
action.
Okay, so if you were to take action, I would have to assume it's malicious prosecution, which is a crime, and I would have no choice but to go to the local courthouse and file criminal charges. And then you'd be summoned by, well, a couple police officers. They won't arrest you. What they'll do is they'll hand over a piece of paper with a summons for you to appear in court. And unfortunately for yourself, I know you believe Crown immunity protects you, but it doesn't from criminal acts. Malicious prosecution is a crime, which is why we don't issue threats to anyone. And I don't react emotionally to anything and get even with people, because malicious prosecution would land me in prison. I don't want to go there because you don't make money there. I'm not threatening you with anything. I'm just saying that you are trying to convince me to give you money that you are not owed, and you can't prove you are owed. You just say you are. That's not good enough. Court order would do it.
And it's not maliciously intended. So I don't understand where that would come in, because again,
it's all how
there
I
are grounds
interpret it.
for it. Because
No, it's
well,
all how
you
it's
can-
my interpretation. I always feel threatened when someone says I must do something. That's a threat. So
I'm getting that feeling from you. Yes.
yes, and
I,
you have to
again,
understand.
this, I guess, just the only intent of my phone call is to say the garnishment is legal. It is not a scam. If is wanting to verify who the officer is assigned to his account, he can search for the Canada Revenue Agency website, General Inquiries phone number. He can call it to verify, and he can get the required information. If your corporation chooses to not follow the requirement to pay that's in place, again, there is the option for assessments to be done and then further legal action.
Okay. But again, it's option. You're the one who said option. So that means you don't have to do anything. It means you will probably choose to do something to get even with me. That's what it sounds like. So I got a couple of quick questions here because I need to know if my life is in danger now. Does the CRA send out thugs or anybody else to our office to intimidate me with physical force to get paid?
Okay, so I'm going to answer your question with a question. Are you new to Canada?
Oh, absolutely not. I'm a Canadian citizen, born in Canada, raised in Canada, but
Okay, so where would that question come from?
Well, I'll tell you why. My dear old mother got a phone call from one of your agents. I don't believe it was you because you're far too pleasant for that. But one of the agents had indicated that not only were they going to take my mother's house from her, but they were going to lock her up and euthanize her pets. Now, the only reason that she knew, or that they knew that she had pets, is that my mother has a sole proprietorship where she takes care of people's animals. You almost sent her to the nut house. I mean, that's a pretty severe threat to issue. Had my mother had a heart attack and died, I would have had no choice but to file the appropriate criminal charges against the CRA agent who made that phone call. That's a very cold and cruel and sinister thing to say, all to make money for a corporation that you work for that I know that CRA representatives are not shareholders within. So why would someone be so callous on the phone? So my question is, are we in danger?
Okay, so that's why this gets your back up. Your answer right there says, oh, that's why your back is up when this comes, when
well,
there is
it's
something.
more so that you want me to steal almost $50,000 from our best staff member. I mean, that's kind of awful too. But I want to make sure that we're not in danger. And I also would like to ensure that nobody is coming over to our offices to take anything without a court order. Is that going to happen? Are you going to do anything callous to us if we do not pay this tab? No. Okay.
No, there is no physical danger. If someone were to come to your office, it would be a field call.
Right.
And it is something that people have the option if someone from Canada Revenue Agency goes on a field call and says they'd like to speak to, for example, you, the 51% shareholder, you would have the option to say no, and that's fine. They would leave you a letter and a card and say, please call me at this number. That's totally up to you. There is no as for if they would be coming to seize and sell anything from the corporation, there would be ample notice of that. That's not something that can happen overnight. That is something that it's a process.
I see.
Definitely
So you would need a court order for that.
That one. So there would have to be for there to be a seizure and sale of anything.
Right.
There would have to be a memo assessment issued. So
And
that would, in this case, it would be like a non-arm's length transfer, right? Because you're paying him when the funds are actually owed.
I see.
To Canada Revenue Agency, where you're paying it. No. So again, with that too, there's no threat to your business to someone coming and roughing anybody up or
okay.
taking
And no one's doing jail time, right?
Not a threat.
There's no prison time for this, right?
No. Where have you heard of that happening?
CRA representatives frequently say this to people, that you're going to jail if you don't pay your taxes. It's actually quite odd that that's the type of thing that gets said. If you're telling me that I can't do jail time, maybe we need to have you being the one to train CRA representatives on how to speak to people, because to make a statement that you're going to prison if you don't pay us would be the crime of extortion, uttering threats, and intimidation. That's about 11 years combined right there. So, it's kind of...
If this is from an incident that let's say about 20, 25 plus years ago, things were done a lot differently in the collections department. So there were a lot of seizures and sales. There were a lot of things that were taken. There may have been people that did end up going to jail. To be honest, I don't know, but that is the jail portion is a rarity. The seizure and sale is coming, I want to say more common now, well, as assessments for funds received that shouldn't have been, or funds paid out that shouldn't have been, things like that. But in regards to physical danger, no. Seizure and sale, again, there is ample notice, and jail time is, I mean, maybe there's a higher levels of collections where that is a thing, but this is not.
Right. So to recap what you just said, I want to simplify it. If me, as a business owner, refuse to pay the garnishment order that you have sent to me, nobody does jail time.
No.
Okay. No, that's a fair statement. Thank you for answering that. Now, you mentioned the seizure part of it. That's when you would get a court order. Is that correct?
So I have never done a seizure and sale on my accounts. Things don't usually, I guess I've never had them progress to that point while I had an account. My understanding with those is so first there is an assessment that is issued saying, let's say, for example, I'm going to give it, the easiest one I can think of is, let's say you received dividends from the corporation when the corporation owed tax arrears, and you had received dividends from those years when it should have been taxes first, then your dividends. So what happens first is you're notified saying, these are the funds that are owing, we're maybe holding you responsible for them. You have time to respond. And then if there's no response, or if there is a response, the response gets reviewed. And if there is enough proof to say, the dividends one is usually it's really hard to disprove, because usually there's a T5 as well as it shows on the T2 as well. But if there is no response, that's when the assessment itself gets completed. It gets, again, sent out to you saying, this is what we are now. In this case, it would be, let's say, the shareholder has received the funds when they shouldn't have, that you are now being held personally liable for this amount. And it gives a breakdown of each year, gives a breakdown of what the interest is, the tax portion is, the penalty portion is, the amount of dividends received, and the amount that's actually looking to be collected. And then again, there's a time frame that has to pass before anything can proceed from there. So like I said, it is definitely not something that happens quickly.
Okay, because
but
yeah, go ahead.
I guess going back to account. So if he has sent in for his returns to be filed, that's fantastic, because because you're not authorized on the account, I can only disclose, let's say, bits and pieces. But let's say the entire balance he's owing is from notional assessment. So he didn't file his returns, but he does have slips on account. The returns were filed on his behalf by the agency. If he is sending in his documents to be filed, or if they're able to be e-filed, which would be significantly faster, that would show up on the account. And then we say, okay, it was showing from said notional assessments, $50,000 that he was owing based on the returns that were actually filed. Let's say it doesn't get rid of his entire balance. Let's say it brings it down to like $10,000. It's like, okay, well then he has the option to, okay, is he going to pay these $10,000, or do we send an amended requirement to pay for now just that $10,000 now that his returns are completely filed up to date? But so you're saying that his documents are with, is it your company's tax lawyer?
Yes. Yes.
Okay.
Yeah. And,
So that would be something I would maybe have you ask your tax lawyer or like accountant, whichever, if they're planning on filing the returns on, or if they're planning on sending them into the Winnipeg Tax Center to be
good question. Okay, you know what?
manually filed.
That's great. Now let me ask you a question, because that kind of leads me to something else I was concerned about, and that is, if we were
Okay.
going to send taxes in, let's just say for argument's sake, I sent everything in the way of taxes on paper. How long does the CRA take to assess that?
So it is dependent. One thing, so it can take a few months. If it's, especially when it's older years that they are looking at now having to paper file as opposed to e-file, it can take several months. If that is the case on accounts, we do encourage people to have a T1 summary from the accountant for all the years. Like usually they can do like 5 years on a page or so. They send in a T1 summary of those years that they have submitted. They'll send a fax in, because we still do things like send in faxes
Okay.
to his assigned officer, and then she can see that, and she can see, okay, based on what notional assessments were done, this is what it has him as owing. Based on what the accountant has sent in, this is what it's showing as owing. And then that can also affect if there's enough of a change, do we leave the garnishment in place, or do we say, okay, at this point in time, we're going to review removing the garnishment? Again, this is all hypothetical because this is not my account, but it would be reviewed. Okay, if there's enough of a difference, or again, even if it shows a credit position possibly for every year, then it's like, okay, well, if this is actually how it ends up, then he's not going to owe anything. If he is still going to owe something based on the information that we've received, it's okay. Well, do we then withdraw the garnishment? Do we just reduce the amount of the garnishment, or do we let it sit and wait until the returns have been processed? So it is, yeah. So again, this is not my account though, so I can't speak for how Arlene would address it, but I would encourage very much that what they are able to e-file, which could be all the years, that is the faster way, because it shows up on the system the next day.
Sure. Let me ask you this question then. How many years can I go back on the e-filing? Because seemingly we've had difficulty going back more than 3. How many years can I go back on e-file?
You know what? I'm going to put this in my group chat and ask.
No problem. Thank you. Appreciate that.
Can one go?
I just wanted to go back very quickly to it while you're getting that answer for me. I wanted to go back to the court order thing. I'm wondering, let's just say, for argument's sake, this does get to the point where you'd like to take a couple of our company assets. Would you be filing in the province of Alberta in the Court of King's Bench for anything that you want done, or would the CRA be going directly to tax court to get an order?
Oh, that I'm not entirely sure, because again, I've never had an account, but let's see. While I'm waiting for my answer, let's see what I can find here.
Okay. The reason being is that I read every single document I could find on Canada Tax Court. Turns out it's a very popular thing for the CRA to do, because tax court, although they say they don't work for the CRA, they kind of do, but it is a tribunal, not a court. And that's indicated by the fact that judges wear a purple sash, not a red one. And on top of that, they also state right on their own homepage that they have no jurisdiction over equity. But we are aware with a few of our clients that the CRA has gone to that tax court to get orders to put liens on homes, which is fraud. So we've been following very carefully a few of the cases that have been brought to real court to have those reversed or stayed, as if you will. And typically those win. So I'm wondering what's going on.
Okay, sorry, I'm not understanding your question. Like, you have employees where there has been, so the first step
Clients. We deal with a lot of rich people, clients.
So let's say so the first step is a certification and a writ that would get put on, and there's a letter sent, 30-day notification. You can pay in full, contact to make a payment arrangement, do something within those 30 days. Otherwise, then there's that proceeding with the property registration as well as land title, depending on what the assets are.
So property registration without a perfection, you mean?
Without a which, sorry?
A perfection. For example, in the province of Ontario, if you put a lien on a property, you've got anywhere between 30 and 60 days to actually file a lawsuit to perfect the lien. That way the courts know you're serious about it, and the person who had the lien put on their property has the right to then defend it in court, to have their day in court. Doesn't sound like you perfect liens. It sounds like you put them there in the hopes that people don't know their rights. What am I correct, or are you correct? Let me hear it.
I am correct. You are incorrect.
So you can just go ahead and put a lien on there without perfection, right?
Yes.
Tell me why that is. Go ahead.
Why wouldn't it be? If there's notice given, it's not like it's a first step thing that happens. It's not like it happens in 2 days.
Well, notice given about anything doesn't make it lawful and doesn't make it valid. You could say anything. I mean, the CRA has the right to issue threat letters to people, but so do I. The only difference is, how does one enforce it? I can't enforce anything because I'm not a cop. You can't enforce anything because you're not a cop. So I'm wondering where this idea comes that you can just put liens on homes and have no consequences for it. Doesn't sound legal to me, just out of curiosity.
But not paying your income tax is also not legal. So where does that come in? Where does that come to pay?
Actually, if you don't mind, I'm going to just offer an alternate opinion on that one. Clause 150 of the Income Tax Act states that you shall do a tax return without the direct request of the Minister of Finance. But the problem for the CRA is that you operate not in criminal law, but in civil law. And in Canada, in civil law, the word shall is a request. It's not must. Shall means must in criminal law, but not in civil law. So if someone says, I shall do something, I say, well, I shall not unless there's a benefit to me. Technically, it's contract law, but only technically. Nonetheless, there is no law that says that you have to do a tax return. I am familiar with the CRA having gone to tax court to get a judge to sign off saying someone shall do their taxes, but not must do their taxes under penalty of contempt of court. So that's why I'm wondering where you think you have that much power. I mean, are you trained to think this? Tell me, please.
I must be having a lot of different accounts that I deal with than you. I've never had that ever be an issue.
Okay, so
in regards to the how many years one can go back to e-file on if they've been notionally assessed, it's about 10 years.
Really? So
that being said, do they have a my account set up? Is the person who is going to be filing the taxes, do they have the authorization on the account to be able to have access to file them? That's another thing too, that your tax person who is doing taxes would have to figure out with Ryan.
Well, Ryan's taxes are figured out, so I'm not one bit concerned about it, which is why we're having this conversation in the first place. First off, I'm saying you, and it wasn't you, it was your, I guess, subordinate, who made a demand of $49,000 and change just because she felt like asking for it. No court order, which I have a problem with. And the taxes were done. And the taxes that were done properly showed that the CRA was incorrect in their assessment. And then we started guessing at how this could have happened. And we realized that assessments are just wild guesses. So the CRA took a wild guess at what my staff member owed in taxes, and you're demanding me to respect a wild guess and give you money because you say so. And I cannot accept that without a court order. Yeah, if you have a court order signed by a judge in one of the superior courts of the country, in this case, it would be Alberta, and the judges wear red sashes, not green and not purple and not gray, then that is something that I would take seriously. Now, I would still appeal it, but at least I would know that the CRA takes what they were saying seriously. But if you're just going to send me a letter that says, give us money or we may punish you, not will, but may punish you, I don't respect that. And I don't have any fear of that beyond the fact that there may have been someone who wanted to do something malicious to us, to which you've said you may not do something malicious, but then again, you may. So should I be concerned or not? Maybe that's the better question to ask.
Again, concerned about what?
You shutting down our company. Let's go with that one, because I know that threat's been issued to a client of ours in the past. I talk to my clients a lot about taxes and whatnot. So I'm just wondering, maybe you've not heard these stories of CRA representatives saying very bizarre things to get paid. It's kind of weird.
I have not. Yeah, no, I haven't had accounts like that before. I haven't had to make a phone call on someone's behalf because they are this concerned. So I guess that kind of brings me to a question: is you're very concerned about your corporation's standing in your employees' garnishment. So what's going on with your corporation that has you disconcerted?
Oh, just the fact that we got a threat letter from your subordinate telling us that if we don't take.
Okay, she's not my subordinate.
Oh, what is she?
She's my coworker. She's my colleague.
Coworker. Okay, colleague. Your colleague issued a threat in writing, and I am the kind of individual who takes all threats seriously because we live in crazy times. I'm sure we could agree on that. And this individual on the phone was not the sweetest of ladies in the world and had indicated that she was protected by everything to do with the Income Tax Act and Crown immunity and a few other phrases as such, to which I said, you're not protected by Crown immunity and I don't want you threatening me. It really is that simple. And here we are, you and I talking. Now, you are far more pleasant than your colleague was, you can say that, but I still fundamentally disagree with what you're saying here, especially considering the fact that you are not prepared to tell me that you will crush us or destroy us if I don't cooperate. It sounds to me like if I don't cooperate with your garnishment order, that all I could expect is for you to say, darn it, we're angry with you, and dang it, we might send you another letter. I mean, what are you going to do? That's the question.
I really won't be doing anything. I was asked to give you a call to see if perhaps we could have a more civil discussion.
Oh, we're having a great conversation. You are very, very polite. Thank you for that.
So there was a letter that was sent out on November the 20th to the corporation to follow up on the requirement to pay that was sent for Mr. over there. And it just says, if you paid any money to him instead of to the agency, you, being the corporation in this case, become liable for the amount that you did not pay us. So let's just say his paycheck that he took home was $1,200. Let's say his take home was $1,200. Canada Revenue Agency should have received $600 of that if it was sent for 50%. If you did not do that, then that $600 your corporation could be held liable for.
And how would you enforce that?
The next pay period.
But how would you enforce that? You're not going to use violence, and you're not using the cops.
Oh, absolutely not.
No, right? So how would you enforce that?
So earlier in our conversation, we had talked about assessments, right?
Right.
About
so you'll assess us.
Being assessed for the funds that you had paid to someone when you were required to pay them to the agency. So there's an assessment. It would be a non-arm's length transfer. You paid money to someone else when it was required to be paid elsewhere. Right. So I'm just going to read you the letter. You become liable if you do not pay the agency when you owe money to the taxpayer. Continue to pay the taxpayer amounts you legally have to pay to the agency, or if you pay someone else instead of us, such as a relative of the debtor or a sibling, whatever, on behalf of the taxpayer, or loan or advance money to the taxpayer within 90 days. And please call me about this matter by November 28th, and then it gives her phone number.
I see.
So,
okay, so
there was that letter that was sent out now saying, if you choose to continue paying him his full wage, there is that option then for the corporation to be assessed for what was to be paid.
So that would mean that the person who makes that assessment is going to be completely and totally held accountable by us. And that particular individual will not be protected by Crown immunity should we choose, and I would choose to file criminal charges. Now, I guess what I think you meant when you said we're going to try to have a civil conversation, I think what you meant to say was you were hoping that I would agree with you if you took a different tone than the previous lady did. Now, I love your tone. It's been great to not have someone screaming into the phone, but you still can't convince me to break the law. And for me to take that money away from my staff member without a court order could be and probably will be construed as theft by the employee, who would then sue us and charge me criminally for stealing his money. And that's a consideration that every corporation should make. So it sounds to me like I'm in danger as a businessman giving you the money and not giving it to him. If I gave you the money and didn't give it to him, I'd be charged by my staff member. But if I don't give the CRA the money and give it to the staff member, the CRA effectively is going to get upset, but do nothing. That's what it sounds like. You're not going to sue me, right?
Me? No.
The CRA is not going to sue me. Is that correct?
I personally am not going to sue you.
Okay, but the CRA won't sue me. Is that correct?
I would like your definition of suing you.
Oh,
this intrigues me.
To file a statement of claim, which would be a lawsuit in the Court of King's Bench in the province of Alberta, where we are located.
I don't know.
Where you would have to serve the document to me by either courier or by process server, at which point I would file a defense. There would be a settlement conference between one of your lawyers and our lawyer, at which point my instructions to the lawyer would be, we want a full-blown trial, please, so that we can question the CRA on their validity. And we will not be taking the stand, so the CRA cannot question us. That's kind of where I would go with that. And I'm sure at that point, the CRA would fail to make a case, and then case law would be made against the CRA, stating that, you don't actually have to abide by a garnishment order. So I think what you're trying to tell me is the CRA will not sue anybody who refuses to respond to or cooperate with a garnishment order. I think we're getting somewhere here. Go ahead. You tell me if I'm wrong.
I'm not following you, to be perfectly honest. I'm calling to say the garnishment is valid. It's a legal document. You choose not to pay it. That's on you. I've told you what's possibly going to happen. You are going to follow up with your tax lawyer to see if returns are going to be e-filed or sent to the Winnipeg Tax Center. I do encourage, if you are sending them to the tax center, to send them priority post, have a tracking number so that you can follow that. Again, it does take several months if he's choosing to do the paper route option, which does then mean that this garnishment remains in place.
Okay.
If the accountant is also willing to send in T1 summaries for the years that are being sent in, and again, as long as it is all the years that are outstanding and is up to date, then that's something that could be reviewed at that time in regards to the garnishment. The garnishment, though, as it stands, is in place. If you choose to not abide by the requirement to pay, the letter has been sent as to what the next possible options are on the account to collect these funds that currently owes. Again, this is not your debt. This is debt. So I guess I appreciate that you're an employer going to bat for him like this, but he chose not to file his returns for however long he chose not to file them. And you can say, you know, this is on me, this is my bad, but ultimately it's not. It's on the person who is required to file their income taxes every year.
Yeah, but we all still have to work within the confines of criminal law. And again, I can't steal from
I'm not talking to you about this.
Please don't get upset. Don't get angry.
We're not getting anywhere. You don't feel like you need to pay this. You feel that we are that the agency is stepping over the bounds that they are legally allowed to do. You can feel that way all you want, but when it comes down to it, the Income Tax Act does have to be followed. This requirement to pay, again, is a legal document. So,
but you have no way to enforce it. So you're telling me I must do something, but you have no way to force me to do anything. You have no way to enforce this.
Should you choose to not enforce this, do you think that as his employer, that is the only option?
Do I think it's the only option for what?
For funds that he is owing. Do you think that you as the employer are the only option?
Do I think that I am my staff members' only option for pay? Is that what you're saying?
Yes.
He's free to do what he wants in his time off. I don't know. I would never stop somebody from I don't know. What are you asking me?
We don't. I'm saying, as his employer, do you think that you are the only option of a way to get the debt that he legally owes paid?
You know what? I must be missing something here. The debt that you say he owes, he doesn't owe. We did his taxes, and I was told that the CRA owes him money. Now, I didn't see the taxes because I'm not the accountant nor the tax lawyer of the company. I'm the guy that does the sales and protects my team. But we do know that the taxes are done.
I'm the one telling you that his taxes aren't filed. So you can say that they're done, but they're not filed.
Didn't I say at the beginning here they're going to be shipped to you this week?
Well, and then I asked, are they going to be e-filed? Or are they going to be sent to the Winnipeg Tax?
Well, now that you brought this up, I think we'll e-file them instead of shipping them. So thank you for that. I really appreciate you telling me that it's going to be faster to get them e-filed.
I greatly encourage it.
Yes, thank you. That's wonderful. Yeah. So that'll speed this process up.
Significantly faster.
Right. But I want to recap the conversation if I could, if you don't mind. I just want to make sure I've missed nothing.
You've got about 5 minutes because all we're doing is going in circles otherwise.
I understand, but I want to make sure that I can get off this call and have a cigar and not worry about anything and get back on the phone and make some money. That's what I'd like to do. Yeah, because I make the most amount of money when I'm smoking. So here we go. We have the CRA doesn't like the fact that one of my staff members made a boo-boo, and it was on me, but the boo-boo was not doing taxes. The CRA assessed taxes, but it was based on maybe previous tax years or just a number that was pulled out of nowhere. A letter was sent to me.
Can I clear that part up?
Sure.
That part with where the dollar amounts came from Yes, in part is by previous year's filings, but also returns that have been sent into the agency. So on his behalf, so whether he's got, let's say he's got T4s, let's say he's even got subcontracting slips, let's say he's got some RRSPs. The information comes from that, but it doesn't include any deductions that he might have to be applied to his return. So that being said, these numbers aren't just pulled out of a hat at random. It is based on, again, previous year's filings as well as slips that have been sent in for him or whatever he has received income from throughout the year. So just so that that part is clarified.
But it is still a guess. You have no idea what the numbers are. You've arbitrarily picked one.
No. Again, if there's a T4 slip and it says this amount of tax was deducted, if there was another T4 slip with tax deducted, that can change your tax bracket. Uh-oh, you're in trouble. Now you're above a tax bracket and you didn't have the right amount of tax deducted because you didn't think to fill out the forms with your next employer. You decided to do subcontract work. Well, there's no tax deducted at source there. You're going to owe for that too. Did you have anything to write off though with that subcontract slip that you did? Oh, you did. Well, that's nice of you to let us know now that you've actually filed your returns. So again, it's not numbers pulled out of midair.
But they're still not, but they're not accurate though, because the taxes weren't done. You selected a number and then issued a threat to me to pay based on the number you selected, whether it's from thin air or an educated guess, it's still not accurate. And then this lady, that your coworker, who really is a little less than laudable when it comes to the manners department, contacts all of us screaming into the phone, threatening us that if we don't pay, that she'll take legal action, but will not define what legal action means. So by the time we were done having the conversation, I'm thinking maybe we're under siege, or maybe she's going to send some thugs our way. That's how she spoke to us. Not the best way to represent your corporation. Nonetheless, I asked to speak to someone else.
She doesn't work for a corporation.
But what does she work for?
She works for Canada Revenue Agency. She works for the federal government of Canada,
which has to be registered as a corporation, just like every other government department. Everything has to.
Anyway, let's carry on. We don't need to nitpick in this department.
All right. Well, either way, I thank you for that. So she issues the statement demanding that I take $49,000 in change from my staff member because she wants me to. And I said, not without a court order. Then she screamed at me saying she's never heard anyone ask for a court order before, which I find disappointing because everybody should, and that legal action will be taken, and wouldn't define it. Now, you and I are talking, and we know that legal action means that maybe perhaps one day a consideration could be made to possibly think about doing something to take some of our money from us, but you don't have thugs that can do it. You don't have police that can do it. You're not going to go to the Court of King's Bench in the province of Alberta to sue us. So what exactly are you going to do? And in my recapping of all of this, the answer is a resounding zero. So I'm going to politely state to you, thank you for this call. It's been very educational, but we are going to decline your garnishment order. We're going to say no, period. We will not take any money from our staff on behalf of any corporation or government agency because a government agency says so and issues threats in a letter and on the phone. But if the CRA chooses to get a court order signed by a judge in the Court of King's Bench in Alberta, we will consider after we lose our appeal. That's what I'm saying. And I don't think I'm being unreasonable. I think I'm actually being very kind and polite and working within the bounds of both criminal and civil law.
Yeah. Sure, we can leave it with that, and wonderful. I will make some notes on the account. I guess again, that important part is if your tax lawyer is able to get those returns e-filed. I mean, if they do them this afternoon, they could show up on the account tomorrow morning, which would drastically change Mr. Prant's account.
Wonderful.
That being said, if they choose to send it into the tax center, then this debt just stays here. So I guess just...
No, we'll do it your way. No. Thank you. Your way is better. And you know,
it
actually...
is significantly faster.
No, it's cool. And thank you for saying that. So why don't we maybe have you do this? The lady that called prior to you, maybe tell her not to scream and yell and just to make the same offer to corporations that you just made. I think you get a lot more cooperation, actually, because now I'm going to cooperate with what you've said there, and we're going to open up the box that I know is being shipped, and we will go ahead and file electronically for my staff member instead. And that way, within, you said 24 hours, I guess, you're going to have his taxes, and there'll be no need for a garnishment order.
Let's say 24 hours, give or take, okay? Because again, I'm not in control of it, but with other accounts,
is
that
fine.
is about
36 will do. Okay, I'm good.
I would go maybe solid 48 to be on the super safe side. But again, it's better to give a higher number and have it take less time.
Well, I can tell you something. I'm such a good guy. I'm going to give you 72. How does that sound?
Well, I have no control over that part, but I will make note on the account that that's what the attempt is going to be on it. My phone number, did it show up on your phone when I called?
I don't think it did, but I also don't have a screen on this phone, so go ahead.
Okay, because do you want my toll free or my local? They both go to
local
my
label, if you don't mind. And I'm sorry, I don't remember your name. I'm very sorry.
That's okay. It's Jessica James.
Okay, Jessica James. And phone number, go ahead.
The local is 431.
Yes.
335.
Yes.
4145.
4145.
My office hours are odd. I do work out of the Winnipeg Tax Services office, so I am an hour ahead of you. My hours tomorrow, your time, are 7 till 12:30. Wednesday, the 26th, your time, they are from 8 till 1:30, but there is a course I have to take in the morning. So I guess why I'm telling you this is if your tax accountant is able to get these e-filed, Arlene is still assigned to the account. It is Arlene's account. I'm not going to be taking the account. It was more just, I guess, maybe someone else for you to talk to about it. But if you do want to call and say, Jessica, we e-filed the returns at this time, and if I would, I guess, ask, is there a T1 summary that the accountant would be willing to fax in so that should this take a little bit of time, there is something that we have on our end to say, this is what the returns should be once done. This is like, we can already see what the notional assessment amounts were.
Okay, so Jessica, the answer is yes. I'm the boss, and what I say goes. There you go.
Okay, so I'm going to give you the fax number. But I want to make sure I give you the right fax number because every time I try to look this up, like when you put it in, here we go. Okay, so I'm going to give you the local as well as the toll free. They're pretty much the same, but better to have both than neither. So the local is 204.
Yes.
984.
Yes.
6838.
Wonderful.
And the toll free is 1877.
Yes.
And then the last four numbers are the same, or sorry, last seven numbers are the same. On the cover sheet of the fax, if they do decide to send it in, just make sure it does have Mr. Perront's social insurance number, who it needs to be attentioned to make sure that it goes to the right place. So I'm going to mark on account that you're going to look into having this done.
Yes.
And that just so that it can also be watched for. And again, in regards to the T1 returns being e-filed, if that is something that is able to be done, then again, but the fax is, I guess, kind of what's what I'm looking for. Like a way for us to see if the returns are taking a bit of time to be done, then again, it is helpful for us to see, okay, this is, where we should be sitting. A big thing though to double check just with Mr. Perront is just to double check that the returns being filed are all the missing returns. So that's just something you'll want to double check with him and say, okay, just so that we have this before we send this in, is this all the years that need to get done?
Excellent. I couldn't be happier.
Okay.
Thank you for everything.
Okay, you've got my number, but again, Arlene is still assigned to the account. I usually work beside her. I have never heard her yell or scream. I've heard her, I would say maybe raise her voice a little bit, but she's usually pretty timid. So I guess I don't know what happened with the call. I wasn't there, but
May I tell you what I think happened? It's not me insulting anybody, but I think that she's just not used to somebody knowing more about the law than she does. And she got frustrated that she could not frighten me. I think that's what happened. Now, that's just only an opinion. You don't have to share it. And I'm saying it with a smile on my face. I'm not being cold when I say that. But I do understand that there are people out there that don't like it when someone knows more than they do. And as a businessman, a guy who I love making money, I want to keep as much of it as I can within the confines of the law. And I want to make sure that I obey the law, but so does the CRA. And this has been very enlightening. And thank you very much for your time.
I guess going back to earlier in our conversation when you had shared, I guess I kind of feel where a lot of this, fear isn't the right word. Anger would be the right word.
Disdain or distrust.
What had happened?
Yeah.
Yeah, is what had happened prior. And I'm sorry that happened because I've only been doing this for 10 and a half years. So I've been in collections the whole time, but I've never heard of something like that. So I can understand how, if this had been your experience previous, how that would put that distrust and that bad taste in your mouth for things going forward. So again, I will make some notes on the account, wait for that fax. I mean, Arlene will wait for that fax to come in. And yeah, hopefully things show up, within the next couple of days. And then this
we're gonna make it work.
I can't guarantee. Yeah, I can't guarantee that things are gonna come off right away because again, it's not my account. It depends how long things take. But again, if go the e-file route significantly faster.
Thank you. This has been great.
Okay.
I hope to talk to you again. Thank you. Take care.
Okay, have a good day. Okay, bye.
And there you have it, everybody. If you are an employer and the CRA says you have to garnish the wages of your staff, they have no way to enforce it if you don't do it. So how dare you steal from your staff and give it to them when there is nothing that they can do to you for saying, no, we won't steal from our people. Our people make us money. The CRA does not make us money. In business, you go with what works and you toss everything else away that costs money and doesn't work. And the CRA, after that conversation, have just proven to all of you that they have absolutely no enforcement powers whatsoever. So for all you who are terrified of the CRA, if you're getting garnishment orders, I will get rid of the garnishment order. We will get your taxes done very rapidly, fix everything up, submit it to the CRA, and send them packing, because that's exactly where they need to go. My name is KevinJJohnston, Canada's #1 tax expert. Hit me up right now at KevinJJohnston.com. Let's put your money where it belongs, and that's back in your pocket.